Tuesday, Judge Tanya Chutkan just issued her final compliance order against Donald Trump. 48 hours, surrender by Thursday at 10 a.m., or United States Marshals deploy with active arrest authority. Filed at 2:17 p.m., 43 minutes ago. This is not another warning. This is enforcement activation. Immediate consequence. Federal law enforcement now has an operational timeline for a potential presidential arrest. A 127-page order. Zero ambiguity. The first time arrest authority appears in explicit language anywhere in Chutkan's orders against Trump. But here is what most of the coverage is overlooking. Trump's response deadline forces the Secret Service into a protocol decision by tomorrow morning. That is 19 hours from now. What the Secret Service decides next determines whether this resolves as a voluntary surrender or as an unprecedented enforcement action. Because if Trump refuses and marshals move, the Secret Service faces a decision with no clean answer. Protect the man or comply with the court. The dominoes are falling. Let me show you the sequence. Quick update from yesterday. On Monday, Trump's legal team filed an emergency motion requesting a 30-day extension, citing logistical challenges with the voluntary surrender. My read was that Chutkan would either grant a minimal extension or shut it down entirely. 5 hours later, she shut it down and escalated. What changed between Monday's request and Tuesday's response? For the first time, the final order uses explicit enforcement language. The U.S. Marshal Service has been formally notified and granted active arrest authority. The 48-hour deadline replaces the 30-day request entirely. A Secret Service coordination requirement has been added. That brings us to today. Chutkan's move transforms this from a question of whether Trump will comply to a question of whether anyone can physically compel a former president protected by his own security detail. The order does not simply require surrender. It authorizes enforcement. Here is exactly what happened and when. 11:47 a.m. Chutkan's clerk notifies all parties that a forthcoming order is imminent. 2:17 p.m. The 127-page order is filed electronically. 2:23 p.m. The U.S. Marshal Service confirms receipt and initiates operational review. 2:41 p.m. Secret Service headquarters convenes an emergency coordination meeting, documented in the court docket and confirmed by a Washington Post-obtained internal memo. The sequence matters on its own. Marshals were notified before the Secret Service. That is a chain of command signal worth understanding. Had Chutkan notified the Secret Service first, it would read as a request for cooperation. Notifying the marshals first signals that this is a law enforcement action. The Secret Service must accommodate not one it has the authority to prevent. The specific language inside the order tells the full story. Page 87. The U.S. Marshal Service is hereby authorized to employ all lawful means to secure compliance, including but not limited to arrest. Page 104. The Secret Service shall coordinate with the U.S. Marshal Service to facilitate the nonviolent execution of this order. Page 119. Failure to surrender voluntarily by April 30, 2026, at 10 a.m. will result in immediate deployment of federal law enforcement. Each of those details narrows Trump's available options in a specific way. All lawful means grant the marshals maximum operational flexibility. Trump cannot later argue they exceeded their authority. The coordination directive places the Secret Service in a support role. They cannot position themselves as a blocking force. The phrase immediate deployment removes any negotiation window after the deadline. No grace period, no additional extension. Voluntary surrender is the only path that allows Trump to control the circumstances of what happens next. The trap is symmetrical. If Trump surrenders voluntarily, he preserves some measure of dignity, controls the imagery, and retains the ability to negotiate the terms of the process. If he refuses and forces a physical arrest, the marshals execute at their own discretion. Location, timing, and manner are no longer within Trump's control. A potential confrontation with the Secret Service becomes a live variable. It is a losing position either way for Trump and a structurally winning one for Chutkan, regardless of which path he chooses. The order also shows evidence of deliberate planning that extends well beyond this week. Page 12 contains a footnote referencing U.S. Marshal operational protocols from 1974, the period during which marshals came close to arresting President Nixon before his resignation. Page 34 cites provisions of the Presidential Transition Act governing Secret Service authority during criminal proceedings involving a former president. Page 67 anticipates and preemptively rejects 6 specific legal challenges Trump's team was expected to raise. Chutkan researched the precise scenario of attempting to arrest a former president protected by the Secret Service and drafted this order based on protocols that have not been invoked in 52 years. This document is not reactive. It is the product of calculated preparation. She anticipated every probable Trump countermove and closed each exit before the order was filed. The immediate effects unfolded within 90 minutes of filing. 2:17 p.m. Order filed. 2:53 p.m. Trump posts on Truth Social, calling the order corrupt and illegal, stating he will not comply. 3:29 p.m. The White House press secretary confirms the president has been briefed and states the judicial process operates independently of the executive branch. 3:47 p.m. Speaker Mike Johnson calls an emergency House Republican meeting for 6:00 p.m. Trump's legal team filed a notice of appeal at 3:16 p.m. to the D.C. Circuit Court requesting an emergency stay of enforcement. The Secret Service spokesperson stated at 3:52 p.m. that the agency is reviewing the order and coordinating with relevant federal agencies and that the protection mission continues. The D.C. Circuit Court conducted a random panel assignment at 4:03 p.m. Senate Majority Leader Schumer stated at 4:17 p.m. that no one is above the law. A Trump super PAC sent a fundraising email at 4:28 p.m. and raised $2.3 million in the first hour. 2 hours and 30 minutes from judicial order to emergency appellate panel assignment. That is the pace at which this is moving. The quote from page 3 of Chutkan's order states it directly. This court has exhausted its patience. The defendant has exhausted his delays. The law will be enforced. Subscribe now. This is accelerating. We are 43 hours from a deadline that has never been tested in the history of the Republic. Federal enforcement action against a Secret Service protectee. Here is how Trump's legal team responded 59 minutes after the order was filed. They submitted an emergency appeal to the D.C. Circuit Court requesting an immediate stay of enforcement pending appeal. They filed a 47-page brief arguing that Chutkan exceeded her authority by authorizing arrest before all available appeals had been exhausted. The filing is documented in the D.C. Circuit Docket 26-387. Why does the speed of the appeal matter? The standard appellate process unfolds across weeks. They are requesting a decision within hours. Their calculation has 3 components: what they are attempting to achieve, a stay of enforcement that pauses Thursday's 10 a.m. deadline until the appeals process resolves, what they are attempting to prevent, an arrest while legal challenges remain pending, and what they are willing to risk an even faster appellate loss if the D.C. Circuit rules against them tomorrow. The quote from their brief on page 4 reads, "No president or former president has ever been subjected to arrest. This court should not permit such unprecedented action while substantial constitutional questions remain unresolved." The translation is straightforward. They are betting that appellate judges will not want to bear institutional responsibility for authorizing the first arrest of a former president in American history. Whether that bet pays off depends entirely on 3 specific judges assigned randomly at 4:03 p.m. panel composition. Judge Ketanji Brown Jackson, Biden appointee, former Supreme Court Justice, who resigned in 2025 and returned to the D.C. Circuit. Judge Patricia Millett, Obama appointee, moderate institutional reputation. Judge Gregory Katsas, Trump appointee, consistently conservative on criminal procedure. That is a 2-to-1 panel composition that does not favor the stay request. For Trump to succeed, his team needs either Jackson or Millett to cross the aisle, or for the panel to unanimously reject Chutkan's enforcement authority. Historical voting data shows Jackson and Millett voted together in 87% of reviewed cases. Katsas has dissented in 34% of criminal procedure matters. The most probable outcome? A 2-to-1 denial of the stay, with Katsas dissenting, meaning the Thursday deadline stands unless Trump escalates to the Supreme Court. The pattern that emerges from this is consistent. Chutkan closes the exits, Trump appeals. The appellate panel is likely to deny the stay. The Supreme Court becomes the last available mechanism. Every step compresses the timeline further. Here is why this situation does not naturally de-escalate. The mechanics are self-reinforcing. Chutkan's order triggered a 48-hour enforcement clock. Trump's appeal triggered appellate review with an approximate 24-hour decision window. Both tracks are now locked to the same Thursday 10 a.m. endpoint, with narrowing room to maneuver. If the D.C. Circuit denies the stay on Wednesday morning, Trump has until Thursday morning to either surrender voluntarily or appeal to the Supreme Court. If he appeals to the Supreme Court, the court must decide whether to grant an emergency stay before Thursday morning. If the Supreme Court also denies the stay, U.S. Marshals will deploy on Thursday morning regardless of any ongoing legal proceedings. Once Marshals exercise active arrest authority, the negotiation phase ends and the enforcement phase begins. That is the spiral. We are 4 steps in: Chutkan's order, Trump's appeal, D.C. Circuit review, and Thursday deadline. As former federal prosecutor Andrew Weissman has noted, once a judge activates enforcement authority with a specific deadline attached, appellate courts are extremely reluctant to override that activation simply because the defendant wants additional time. The window for off-ramps closes at noon on Wednesday. If Trump signals voluntary surrender before that point, Chutkan may accept a modified deadline of Thursday at 5 p.m. instead of 10 a.m. If the D.C. Circuit grants a stay, the clock pauses pending full appellate resolution. After Wednesday noon, the Thursday 10 a.m. enforcement timeline becomes effectively locked. The historical parallel is precise. In 1974, President Nixon resigned 72 hours before U.S. Marshals were scheduled to execute a comparable enforcement order. The mechanism worked then. Escalation forced a decision. The same mechanism is operating now. The escalation forces a decision. The outcome of that decision this time is genuinely uncertain. While Trump and Chutkan were locked in their direct confrontation, the Secret Service entered the picture as a third institutional actor. Director Kim Cheadle's internal memo, obtained by CNN at 5:34 p.m., complicates the straightforward enforcement scenario in ways that the coverage has not fully examined. The Secret Service holds statutory protection authority that operates independently of judicial orders. The agency does not report to federal courts. Its institutional mission is the protection of the protectee, not compliance with judicial process. If Secret Service leadership determines that an arrest attempt creates a credible safety risk, the agency possesses the authority to intervene. The memo states the Secret Service's goal as facilitating lawful judicial process while maintaining the integrity of its protective mission. The actual institutional interest the agency is managing is avoiding any direct confrontation between competing federal law enforcement agencies. If marshals move to execute an arrest and the Secret Service physically blocks them, the result is a constitutional crisis for which no legal precedent exists. However, the memo also documents joint operational planning between the Secret Service and U.S. Marshals for Thursday, including an advanced site survey of a potential surrender location. That detail reveals the Secret Service is not preparing to prevent the enforcement action. It is preparing to accommodate a surrender scenario. Impact on Trump. The Secret Service will not function as a human shield against enforcement, eliminating any strategy built around sheltering behind the protection detail. Impact on Chutkan. Secret Service cooperation validates her enforcement authority in practice. But the memo contains a complication. It also states that if Trump directs movement to a non-surrender location Thursday morning, the Secret Service will continue its protection mission in transit. Translation: if Trump enters a vehicle Thursday morning and instructs his detail to take him to Mar-a-Lago rather than to the courthouse, the Secret Service will protect him along that route. That creates a third scenario beyond voluntary surrender and arrest, one in which Trump does not surrender but also does not get physically arrested because the Secret Service maintains a protective perimeter around him while he actively evades a federal arrest warrant. That is a constitutional standoff scenario. U.S. Marshals holding active arrest authority on one side, Secret Service holding protection authority on the other. No existing legal precedent for resolving the conflict between them. This is getting more complex by the hour. Stay with me. We now have the judiciary ordering arrest, the defendant appealing, and the Secret Service signaling they will protect him regardless of the enforcement outcome. Three federal authorities with conflicting mandates converging on a single Thursday morning deadline. Could you step back and look at what is actually happening at the strategic level? Trump's strategy is to delay and run out the clock until the political landscape shifts ahead of the 2026 midterms, 6 months from now. He is willing to sacrifice legal credibility and his relationship with the judiciary to achieve it. Chutkan's strategy is enforcement before November. Prevent Trump from outlasting the judicial calendar. She is willing to absorb the risk of an appellate reversal or a constitutional confrontation if enforcement fails. The Secret Service's strategy is institutional preservation, maintain credibility with both the judicial system and their own protection mandate simultaneously. The point where all three strategies conflict is Thursday morning. No compromise solution satisfies all three simultaneously, which means Thursday produces one of three outcomes: voluntary surrender, an arrest attempt with Secret Service cooperation, or a standoff with no legal resolution available. Former federal judge Michael Luttig framed Chutkan's move this way. She forced the question that should have been resolved in 1974. Nixon resigned before the country learned whether marshals could actually arrest a sitting or former president. Now we find out. Even conservative legal scholar Jonathan Turley has acknowledged that Trump's legal position is weak in the absence of a granted stay. Compliance is legally required. When analysts across the ideological spectrum agree on the legal requirement, that is the baseline read. The fair counterargument from Trump's defenders is that enforcing the order before all appeals are exhausted violates due process and establishes a dangerous institutional precedent. That argument has procedural merit on its face, but Trump's legal team had 14 months following the original compliance order to pursue every available appeal. They delayed filing until enforcement was imminent. Their own timeline reveals the appeals process was being used as a delay mechanism rather than a genuine legal challenge. Chutkan identified that pattern and activated enforcement to neutralize it. The bottom line: this is not fundamentally about whether Trump eventually complies. It is about whether anyone can compel him to comply on the court's timeline rather than his own. Thursday morning provides a definitive answer to that question. Either federal judges retain enforcement authority over their courtrooms, or defendants who travel with security details exist in a practical category outside the reach of judicial enforcement. This pattern has a historical precedent. In 1974, a federal grand jury named President Nixon as an unindicted co-conspirator. Judge Sirica prepared an enforcement order for deployment if Nixon failed to cooperate. Nixon initially refused and claimed executive privilege. The result? Nixon resigned on August 9, 1974, 72 hours before U.S. Marshals were scheduled to execute an arrest warrant. The timeline from enforcement threat to resignation was 17 days. The key distinction between then and now: Nixon was a sitting president who could resolve the confrontation through resignation. Trump is a former president in civilian status. There is no equivalent mechanism available to him, but the core dynamic is identical. The judge sets a deadline, the defendant delays, enforcement is authorized, and the defendant faces a binary choice: comply or face arrest. John Dean, Nixon's White House counsel, observed that everyone understood marshals would not physically breach the White House, but the order's existence was constitutionally catastrophic regardless. Nixon resigned to avoid the test of whether they actually would. We are at the enforcement-authorized stage now. If history repeats itself, Trump complies at the last possible moment and claims victory anyway. If it breaks from the historical pattern, Trump forces the test Nixon avoided, and marshals attempt an arrest that creates constitutional precedent with no equivalent in American history. Thursday morning determines which pattern holds. If you have ever wondered in an abstract way whether former presidents are genuinely subject to the same legal enforcement mechanisms as everyone else, Thursday morning answers that question with action rather than theory. You have seen former presidents at public events, giving speeches, living without visible constraint. The assumption embedded in that image is that if they committed crimes, they would face consequences equivalent to what anyone else would face. But no former president has ever been arrested in the history of the United States. Before Thursday, that is an untested assumption. After Thursday, it becomes either a confirmed fact or a demonstrated fiction. If Trump surrenders, it proves courts can compel even former presidents to comply with enforcement orders. If he refuses and gets arrested, it proves enforcement mechanisms function regardless of the subject's status. If he refuses and does not get arrested because the Secret Service maintains a protective perimeter, it proves that Secret Service protection creates a practical category of legal immunity that the judicial system cannot penetrate. Whatever happens Thursday becomes the operational precedent for every former president who follows. What happens next? Wednesday, 11 a.m., D.C. Circuit oral arguments on Trump's emergency stay request. 3 possible outcomes. First, stay granted, Thursday deadline paused pending full appellate review. Second, stay denied, Thursday deadline stands, Trump must surrender or face arrest. Third, partial stay, court extends the deadline by 7 days to allow Supreme Court review. Former appellate attorney Sarah Isgur assesses outcome 2 as most probable, because Trump's brief fails to demonstrate a constitutional violation. It demonstrates only disagreement with the trial court's enforcement timeline. Also on the operational clock, Wednesday 2:00 p.m., U.S. Marshals planning deadline. Thursday 10:00 a.m., surrender deadline. Thursday noon. If no surrender, marshal deployment is authorized. These connect directly. The D.C. Circuit's Wednesday decision determines whether the Thursday deadline is legally enforceable. If Wednesday produces a stay denial, Trump has 23 hours to surrender voluntarily, escalate to the Supreme Court, or prepare for an arrest attempt. If Wednesday produces a stay granted, the entire timeline pauses and Trump wins the delay. The Supreme Court pathway matters as a final variable. If the D.C. Circuit denies the stay Wednesday morning, Trump's team can file an emergency application to the Supreme Court by Wednesday at 5 p.m. The Supreme Court could grant a stay, deny it outright, or request a response from the government before ruling. The wildcard scenario? Trump leaves jurisdiction Wednesday night, flies to Mar-a-Lago, and dares marshals to execute a federal arrest warrant across state lines, potentially with Florida's governor creating additional friction for the enforcement operation. That would force marshals to execute the warrant in a state where the political environment is maximally hostile to the effort and where local law enforcement's cooperation is far from guaranteed. The countdown. Wednesday, 11 a.m. Oral arguments, 20 hours from now. Wednesday, 2 p.m. Marshal planning deadline, 23 hours from now. Thursday, 10 a.m. Surrender deadline, 43 hours from now. Thursday noon, potential arrest, 45 hours from now. By Wednesday evening, we will know whether the Thursday deadline is legally enforceable or has been paused. By Thursday noon, we will know whether Trump surrendered, was arrested, or whether enforcement failed entirely. This is the fastest timeline in presidential legal history. 48 hours from judicial order to potential arrest of a former president. But Wednesday's D.C. Circuit decision is the actual signal. Stay denied means enforcement proceeds as ordered. Stay granted means Trump wins the delay he has been engineering for 14 months. Subscribe. I will break down the D.C. Circuit decision the moment it is released. The ruling could arrive late Wednesday or early Thursday morning, and the timing of when it drops will itself communicate something about the internal dynamics of the three-judge panel. Here is exactly where things stand right now. Chutkan's final order has been filed with a 48-hour enforcement deadline attached. Trump has appealed to the D.C. Circuit requesting an emergency stay. A three-judge panel has been assigned, 2 Biden appointees, 1 Trump appointee. The Secret Service is coordinating with marshals while maintaining deliberate ambiguity about its posture for Thursday morning. The U.S. Marshal Service has active arrest authority designated for Thursday at 10 a.m. Active clocks running, Wednesday 11 a.m. Oral arguments, 20 hours remaining, Wednesday 2 p.m. Marshal operational planning deadline, 23 hours, Thursday 10 a.m. Surrender deadline, 43 hours. Thursday noon arrest authorization active, 45 hours. Moving pieces, Trump awaiting the D.C. Circuit decision while preparing a possible Supreme Court application, Chutkan's order standing unless the appellate court intervenes, the D.C. Circuit conducting its emergency stay review, the Secret Service coordinating with marshals while maintaining deliberate ambiguity about Thursday's scenario, the Marshal Service planning Thursday operations contingent on Wednesday's ruling. Locked variables. The original compliance requirement is no longer being contested on the merits. Only the timeline is being litigated. Open variables. Whether the D.C. Circuit pauses the Thursday deadline, whether Trump escalates to the Supreme Court, whether surrender happens voluntarily or enforcement is required, whether the Secret Service facilitates or complicates an arrest attempt if it comes to that. 3 things I am specifically tracking heading into Wednesday. First, the D.C. Circuit panel's decision timing. If the ruling comes early Wednesday morning, that suggests quick consensus among the judges, likely a denial. If it arrives Wednesday evening, that suggests internal debate among the panel members. Second, whether Trump's legal team files a Supreme Court emergency application preemptively before the D.C. Circuit rules. Filing before the appellate decision signals they expect to lose. Waiting signals they have some confidence in the stay. Third, Secret Service operational posture. Wednesday evening, increased security perimeter at Mar-a-Lago signals preparation for a non-surrender scenario. Coordination presence at the federal courthouse signals preparation for a voluntary surrender. Wednesday evening is the signal point for all 3 of those indicators. I will be covering the D.C. Circuit decision in real time and tracking the operational movements as they become visible. Thursday morning could mark the moment American history records its first arrest of a former president, or it could mark the moment the country discovers that enforcement has limits even a federal judge cannot fully overcome. We will know in 43 hours.